morning, guys, and welcome back to my channel. So it has been months and months and months since I've posted something, and I'm so sorry for that. I'm really excited. I'm done with the bar exam, and that's kind of why I took the hiatus. So what you are about to see is a video that I recorded in May when I wasn't quite sure how much studying was going to take up as far as my time was concerned, and if I was going to be able to keep up with YouTube. I wasn't. I studied a lot. I don't know if I passed, so please don't ask. So this video is going to be sort of long. It's not super legal. You will see why. It's basically some advice on steps that you can take when someone has stolen your intellectual property. Things that you can do that don't require that you hire an attorney, and things that you should do on your own in order to protect yourself and protect your assets. So I hope you enjoy the video. If you have questions, of course, leave a comment, let me know. And I'm gonna put everything that I say in the comments, so you can skim through the video if you want. It might be kind of lengthy, I'm not sure yet. I'm not quite done with editing, so you don't exactly know where I am. And yeah, I guess that's it. I'm hopefully going to make a couple more legal videos. They're saying that YouTube for law firms is the next big thing, so I'd like to think that I have a jump start on everybody since I've had my own channel for a while now. I hope you guys enjoy it, and I will see you in the next video, hopefully sometime next week. Have a good one, guys. So today we are on episode 9 in the legal fitness series that I've been doing. I'm sorry I didn't get a legal fitness video out for you last week, but I did put up a workout video, so I hope you guys were able to check that out. Today we are going to discuss how I think you should handle a situation, specifically when someone has stolen or is using your intellectual property, whether it be for monetary reasons or not. If they're using it and you didn't give them permission to use it, I'm just gonna go over with you the steps that I think you can take before having to hire an attorney. So basically, this episode isn't necessarily going to be super legal in the sense that I'm not going over any types of laws or anything along those lines, but it is kind of meant to give you an idea of what your options are if you find yourself in this situation. Like I always say before we get into it, this video is not meant to be legal advice. This is really just some general knowledge for you to use. I am an attorney licensed here in the state of Florida, but I am not your attorney. So take everything that I say and just use it to further your knowledge, but please don't rely on it as legal advice because I don't know you and I don't know your situation. Okay, so what are some things that you should be doing before you even reach a point where you notice that someone's using something of yours or stole a picture of yours or is using your ebook and passing it off as their own? First of all, I want you to have your intellectual property registered, right? So copyrights, trademarks, all of that should be registered at this point in time. And if you have questions about that, check out some of my other videos. I have a copyright one and I also have a video on trademarks. But of course, leave a comment below and I can help you with that as well. But the most important protection for protecting yourself and your brand and your company is going to be to have your intellectual property already registered with the correct organization. Another protection that you definitely want to make sure you have, especially if your IP is connected to a website, you need to make sure you have a very strong terms of service with your website. If you're selling an ebook or something on your site, your terms of service needs to explain exactly what someone can and cannot use that ebook for once they buy it and download it from you. If you have a really strong terms of service that lists out how someone can and can't use your materials, it makes it a lot easier to go after them when they misuse your material. Another great protection and habit to get into is to make sure you have the copyright symbol, the C in a circle, and also the trademark symbol, whether your trademark is registered or not, because those symbols let people know exactly what you are claiming is yours. And if you're not using the trademark symbol or you're not using a copyright symbol on your website, then people, although they should know that it belongs to you, they aren't necessarily put on notice, and this just puts them on notice. With the copyright symbol at the bottom of your website, make sure you have a range of years or a year. If your website's only been up for a year, then just go ahead and put that year there so that everyone knows the length of time that you've held that copyright. So let's say that you've done everything that I've just said, you've got everything registered, you have the appropriate symbols being used, you have a great terms of service, and you are like protected at the highest level with your intellectual property, and someone has still decided to take it upon themselves to take what you made and use it for their own benefit. What are you supposed to do? So what I'm going to go over right now are the steps that I suggest you take. These are very, very general, so they're going to depend greatly on the situation that you're in. And if you're dealing with something that costs a lot of money or that is very, very central to your business, you might want to consult with an attorney before taking any of these steps. But just as general guidelines, these are the things that I suggest you do. So the number one thing that you need to do first is to document the infringement. Don't let that person know that they're using your stuff without first getting screenshots. Say they're passing out your picture at an event or something and they're using it on their marketing materials and you just happen to come across that. Get that, save that. Any way you can document that the person is infringing on you, you want to save all of that, and you're kind of building up your case. You're going to need all of that for evidence down the line if this person is unwilling to take down the infringing material or stop using what is yours. The next thing you're going to want to do is to actually reach out to this person. And I know that seems scary and you might be thinking like, oh, I have to have my attorney do that, or I don't have an attorney, so I probably shouldn't do that. You 100% can reach out to this person. And your first attempt at speaking to them, you definitely want to do it in writing. So email or some kind of direct message. If they're infringing on your Facebook and that's where you notice it, you can send them a message via Facebook, but it really needs to be in writing. I don't suggest calling them because down the line, you won't really have any way to prove that you did reach out to them and that you did make an attempt to stop the infringement. That's why email or messaging or even a letter is the best way to go here. And then of course, save that correspondence for your little pile of evidence that you're creating surrounding the fact that this person has stolen your items and is using them for their own benefit. So just come at them nicely and say, hey, you know what? I am the rightful copyright owner in this, or I'm the trademark owner in this particular item, and I see that you're using it. I would really appreciate it if you would take it down because, you know, you don't own that, I do, and it would be a really big help, yada, 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 something along those lines. And if you're really lucky, they'll listen to you and they'll say, okay, fine, sorry, taking it down. Everything's good and you don't have to do anything else. But what happens if they don't listen to you? They don't take it down or they completely ignore you. So step 3. So if you have the ability to contact an attorney about what's going on, I would say maybe at this point you can go ahead and do that. If contacting an attorney or hiring an attorney is really out of the realm of possibility, we're gonna go ahead and send one more letter from you before you actually take any further legal steps that might cost you money. So this next letter that you're going to send is going to be a little bit more official. Send it on your company's letterhead, actually send it through the US mail, and this letter is not gonna be so friendly. You're going to be very stern, and instead of saying, listen, you know, I own the copyright to this and I would really appreciate it, you're gonna say, I am the copyright owner to this item. I see that you're using it. What you are doing is illegal, and I am requesting that you take it down now or I will have to take legal action. A lot of people don't like to threaten legal action, but the point here is simple. If you're the copyright owner or you're the trademark owner and this person is using it without your permission, you can sue them all day, every day. So whether you sue them or not really isn't the issue. The point is that you can, and they need to be aware of that. You can soften it up by saying something like, you know, I hope we can resolve this without me having to take legal action, but, you know, something like that, but just so that they know that you're serious, that you are the owner and that you plan to do whatever it takes to get them to stop using your intellectual property. Hopefully, before you send that letter, you have already registered your copyrights, which I mentioned in the beginning, because as we all know, you cannot sue for copyright infringement unless your copyright is registered or in the process of being registered. So make sure that's done before you threaten a lawsuit. Just a heads up. Okay, so say this still doesn't get the job done. What is your fourth option? You're not ready to get an attorney involved and you're not ready to file a lawsuit, but you do have another option in between. And that is to file a DMCA takedown notice. So with a DMCA takedown notice, this is something that you can do on your own. Usually, I mean, if you Google it, you'll see what it is. Say you're using YouTube and a video of yours has been taken and is being used by somebody else. So on the YouTube website, you can actually fill out the DMCA takedown form. So once you fill out this form, it's going to require that the website who's hosting your content, whether that's Instagram, YouTube, Facebook, they're, pretty much every website, even Google, is going to have this form for you. You file the DMCA takedown, and then that party, so they're kind of like the third party, is required by law to go ahead and take the content down until the issue is resolved. So that's really helpful in the sense that the person is being forced to stop using your content, even if it is only for a few weeks while the issue gets resolved. So after you file your DMCA takedown request, YouTube, in our scenario, will take down the video, and the person, they either they give up and they say, fine, you know, I don't own the rights to the video, I'm not gonna fight it, or they file a response explaining why they think they have the right to use that material. If the person decides to go ahead and file a counter response, you as the copyright owner, so this is a copyright law, but it's also applied in trademarks, but you would have 10 days to file suit against that person to stop the infringement. But usually with DMCAs, what will happen is the other person will file their counter response, and the third-party hosting site, you know, the YouTube or the Etsy or the Instagram, will decide that the person's counter response really isn't good enough, and they're not going to put the content back up. So then essentially you've won and you haven't had to file a lawsuit, which is great. The issue arises when YouTube or whomever decides that the counter response is actually fine and they allow the content to go back up. And then at that point, you would want to go ahead and move forward with your next step. So the next step here is going to be to have a cease and desist letter sent from an attorney. If you're not willing to invest in filing the lawsuit just yet, the 10-day time period from the DMCA takedown doesn't preclude you from filing suit later down the road, right? It might start the statute of limitations on when you can file suit. So statute of limitations varies depending on the law and the issue that you're dealing with. In this scenario, I don't exactly know what it is for intellectual property, but it's usually like, you know, a year or 2 years or something along those lines, from the point that you were put on notice that your stuff was being infringed. So the filing of a DMCA takedown request would most likely start the clock on a statute of limitations, simply because it shows that you as the intellectual property owner knew that someone was infringing. But just because you don't file the suit within that 10-day time span, you will still have time to file suit down the line. So if you're not fully ready to invest in the lawsuit just yet, you do have one more option, and that's going to be to have an attorney send a cease and desist letter. Because a lot of times what we see with these sorts of cases is the other side either gets a little bit more scared when something comes from an attorney, they realize that you're more serious about this than they thought, and they also realize that they don't necessarily have the resources, nor do they really feel like fighting it out or hiring an attorney to handle it themselves. And at which point they would be able to take down whatever it is they're using, or give you credit, or they'll be willing to do what it is you want them to do with the infringing material. So even though your attorney may say exactly what you said in your angry second letter to this person, for some reason, people just respond differently to attorneys. And I guess that's a good thing, because I am one and I need a job. So for whatever reason, we kind of have a tendency to scare people, and that can be good for you in this scenario. I think the garbage truck's here, so I'm gonna finish up. We're almost done here. Once your attorney sends the cease and desist letter that requests the person to either take down the picture or stop using the infringing material, or simply give you credit for the intellectual property, if the other side has decided that they don't care and that they're going to hire an attorney for themselves and that they're willing to fight you on this, then your final step is going to be to file a lawsuit. So just make sure that you have kept records of every correspondence you've had with this person, that you have screenshots of the infringement happening, or that you have actual physical evidence of the infringement happening, that you have kept literally any record and every record you have of this entire situation, so that you can give that to your attorney and they can fight this thing for you. And a couple minor things, I've already mentioned it twice, I'm going to mention it one more time. Make sure your copyright is registered, because if it's not registered or in the process of, you can't file suit. And with your trademark, you are eligible for so much more money in damages if it is registered. So go ahead and make sure your trademark is registered as well. That is pretty much it for today on cease and desist letters and how to go about handling if someone's trying to steal your stuff. If you have any questions, let me know. Go ahead and leave a comment down below, or you can find me on Instagram at Lifting Lawyer, and you can send me a direct message there. You You can also send me an email. My email will be down below in the box. I'm going to try to sum up what we said here in the box as well, although like I said, this is a little bit less legal as far as laws go and more just my best advice for you. Don't be afraid to reach out to somebody who is stealing your stuff. Make sure you have it documented before you let them know that they're doing something wrong. Make sure all your stuff is registered. Make sure you have a great terms of service on your website, and hopefully everything will work out in your favor. Thank you guys so much for watching. Go ahead and subscribe to my channel so you don't miss next week's video, and then also give this one a thumbs up so that more people on YouTube can see this video. And for next week, for the last and final episode of this Legal Fitness series season 1, I would like to do a Q&A. So if you have questions that you are curious about yourself, leave them down below or find me in any of the avenues that I just went over. And I will see you guys next time. Have a great week, and thank you for watching.